Hello and welcome. What we're going to be doing today is we're going to be looking at the Bill of Rights and some of the implications that the Bill of Rights has had on American society throughout history. Here's a warm-up. This is a chart analysis. This is something similar to what you'll see on the AP exam, so this is something that you want to go through, try and look at, and then determine the answer. So pause the video now if this is something you'd like to do. So the first thing we have to look at is what is the Bill of Rights? The Bill of Rights are the first 10 amendments to the Constitution. And these amendments, as we talked about in the previous lesson, were added largely because many people weren't very happy with the final product of the Constitution. And they were afraid that it didn't go far enough in outlining all of the rights and concepts that American citizens should possess. And that without an outlining of those things, an outlining of the basic rights that people had, that it wasn't clear what the government had to protect and what the government didn't have to protect. So this is one of the main reasons why this is added to the document. So we've got the First Amendment. And the First Amendment is one of the big ones that we have to look at because there's quite a few things that are included within this. The first concept that we have within this is the concept of freedom of religion. And what it says is, Congress shall make no law respecting an establishment of religion. This is known as the Establishment Clause. This is something that you definitely need to be able to identify when looking at the test and FRQs and things like that. And it also says, or prohibiting the free exercise thereof, so the Free Exercise Clause. So we've got two main clauses that we look at. One is the Establishment Clause. The government cannot establish an official state religion, nor can they do anything to promote any religion within the United States. They're not allowed to promote religion, nor are they allowed to inhibit or prevent or say something negative about other religions. Nor are they allowed to prohibit the free exercise of religion. Now, there are some limitations to that. You can't kill anybody in the name of religion because that goes against murder laws. You can't do things that would make it unsafe for the public. So even though you're allowed to believe whatever you want to believe in, it doesn't necessarily allow you to practice whatever you want to practice. Also in the First Amendment, it says the government does not have the ability to abridge the freedom of speech. So we have the ability to say what we want to say. Once again, with certain caveats. We're not allowed to incite violence. We're not allowed to tell people to commit crimes. So there are limitations to freedom of speech. We also have freedom of press, the right to peaceful assembly with each other, and to petition the government for a redress of grievances. The First Amendment sets up the argument for the separation of church and state, as we've already talked about. Then we've got other concepts that go along with the First Amendment. One is slander. Here are some things that you also cannot do based upon freedom of speech. You're not allowed to purposefully say things that are false in order to damage someone's reputation. Nor are you allowed to write those things down. That's libel. Then we've got the Second Amendment. So even though the Second Amendment is only one sentence long, it is definitely one of the most controversial amendments in American history. And what that amendment says, and it depends on how you read this amendment as far as how you interpret it. Those who tend to be more pro-gun control, and pro-getting rid of guns will look at the first part of the amendment, where it says, a well-regulated militia being necessary to the security of a free state. Most people who look at gun control and they look at the removal of guns in the United States will look at that first part of the Second Amendment and say, we no longer need a well-regulated militia because of the type of power that our American military has, that we no longer need to have firearms. Now, the back end of that amendment, the right of the people to keep and bear arms shall not be infringed, is where the pro-gun camp comes into it. And this is the part of the amendment that they use to justify why we need guns and why our gun rights are constitutionally protected. Then we have the Third Amendment. The Third Amendment says, no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So this goes against some of the quartering things that were done during the Revolutionary War, where the British were just kind of sticking British troops within American homes. And this is something that we outlaw. It's actually an amendment we've never had to use. Then we've got the Fourth Amendment. The Fourth Amendment says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what we see here is an amendment that says unreasonable search and seizure is illegal. So the way that a search and seizure can take place within the United States are really in three different fashions. One, they've got probable cause. So if you're driving your car down the road and all you were doing was speeding, an officer does not have the right to search your vehicle just because they want to search your vehicle. Now, if you were speeding and swerving around the road, that may give them probable cause to search your vehicle for something that may have caused you to be impaired while driving. If you roll down the window and a certain pungent odor escapes your window and an officer smells that, that's going to give them probable cause to be able to search your vehicle. If they're looking for a vehicle that matches that description from a murder case and they see blood all over your car, that's going to give them pretty good probable cause to be able to search your vehicle. Okay, so one, we've got probable cause. Two, we have warrant. They have a warrant from the courts that allow them to be able to search that. If they have a warrant, you cannot stop them from being able to search your vehicle. And then three, consent. If they ask to search your vehicle and you say yes, that gives them legal right to be there. And we just talked about probable cause. The police must have a reasonable basis to believe the person or premises is linked to a crime in order to be able to search it without consent or without warrant. And then we've got the Fifth Amendment. The Fifth Amendment, once again, is a very meaty amendment that's got a lot of things to it. What the Fifth Amendment says is no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. So what that means is a grand jury is the type of jury that goes through and looks at all the evidence in the case and then makes a determination as to whether or not that case should move forward to be able to see if there's enough evidence for it. Now, this is the case except in cases arising in land or naval forces or in the militia. And that's because courts, or military courts run on a very different system, and they have the right to be able to try their own crimes. When in actual service in time of war or public danger. So, once again, if you're in public danger or if it's war, some of those rules can be bent a little bit. Nor shall any person be subject for the same offense to be twice put in jeopardy or life or limb. So this is the double jeopardy cause. You cannot be put on trial for the same charge crime twice. So if you murder one person and get off and then go murder somebody else, they can try you for that second murder. They can, however, never charge you for the same crime twice, even if new evidence comes up to be able to show you're guilty, or even if you admit to it after that trial is over. Once you've been tried for a crime, you can no longer be tried for that crime ever again. Nor shall be compelled in any criminal case to be a witness against himself. You cannot be forced to testify against yourself in a court of law. This is the concept of pleading the fifth. Now here's the thing that you have to keep in mind with pleading the fifth, though. There was recently a court case that went to the Supreme Court in which an individual was tried because he refused to provide information to the police. Now, at the time when he wasn't providing information to the police, he was not a suspect in that crime. But what they did was they used his silence and they used his unwillingness to testify as evidence within the court. So what ended up coming out of this trial, and he was actually found guilty of this murder. Now what actually comes out of this trial is that you must verbally ask for your right to be silent. So if you ever don't want to provide information to a court or to the police, every question that they ask you, you must say, I choose to invoke my Fifth Amendment right to silence. The amendment also states that you shall not be deprived of life, liberty, or property without due process of law, which means that everybody has the right to have the ability to go through the entire legal process before anything is taken away from you, before anything can really be held against you. Nor shall private property be taken for public use without just compensation. This is known as the eminent domain clause. All right, so what this means is that the government does have the right to be able to take your public property or to take your private property for public use. They just must provide you with compensation for that. So what are some other things that go along with some of these things? One, we've got the writ of habeas corpus. Habeas corpus is a judicial mandate to a prison official ordering that an inmate be brought to the court so it can be determined whether or not that person is in prison lawfully and whether or not he should be released from custody. Within habeas corpus, what they're going to do is they're going to read you what the charges against you are, which allows you to be able to start putting your defense together. Now, something that Congress cannot do is pass something that's referred to as a bill of attainder. Bills of attainder are legislative acts pronouncing a person guilty of a crime, usually treason, without trial and subjecting that person to capital punishment and attainder. Such acts are prohibited by the U.S. Constitution. So what a bill of attainder tries to do is it's where Congress tries to pass a law saying that you're guilty of a crime, but that's before you ever go through trial, which is something that is not legal and cannot be done. Then we've got the Sixth Amendment, which is also a media amendment. The Sixth Amendment says, in all criminal prosecutions, the accused shall enjoy the right of a speedy trial and public trial. So, the reason why it's public is to make sure that nothing devious is going on and allows the public to be able to check and provide some transparency to the things that are going on. And speedy means that they can't hold you indefinitely. They can't just throw you in jail for a long time without making any sort of procedure. Now, one of the questions that I get a lot with that is, how can a trial take 3 years to put together? Well, the entire time that that is going on, if you've got something where there's a long evidence collecting period, is that there are constantly motions and hearings being held with the judge to ensure that the court's time isn't being wasted and to ensure that the defendant's time isn't being wasted. All right. You also have the right to an impartial jury of the state and district wherein the crime shall have been committed. So, if you commit a crime within Florida and it's a state crime, that is where that trial is going to be held. All right. Most of the time, it's also going to be held within the county that crime was committed as well. And that district is going to have been previously ascertained by law. Okay. You also have the right to be informed of the nature and cause of the accusation, which goes back to the habeas corpus concept. You have the right to be confronted with witnesses against you. So, if you are on trial, and if people want to testify against you, they must do so in open court. You must be able to see who those individuals are, and that's so that people don't try and hide under the cloud of anonymity to be able to say whatever they want to. You also have the right to have compulsory process for obtaining witnesses in your favor, which means that, say an individual saw that you did not commit a crime, and they don't like you. They can't not testify on your behalf because they don't like you. You have the right to be able to force them to testify in court because of the Sixth Amendment. And you have the right to a lawyer, the assistance of counsel. You have that right. They must provide a lawyer on your behalf. Then we got the Seventh Amendment. The Seventh Amendment says you have the right to sue over $20. It's an outdated amendment, but we also have to realize that in 1791, when this amendment is passed, $20 is an awful lot of money. Now, another question I get a lot of times is, why don't we just change this amendment? Well, in order to change this amendment, it would be very costly, it would be very time-consuming, and it's something that really doesn't get used anymore, so there's no point. Then we have the Eighth Amendment. The Eighth Amendment says that you should not be able to set excessive bail, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So, when it comes to the idea of excessive bail should not be required, the bail has to fit the crime. They're not going to put a bail of $1 million for somebody who has stolen a Snickers bar. So, it has to be in line with the crime as far as how much bail is going to be. Moving to the Ninth Amendment. The Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others restrained by the people. So what this amendment means is that the Bill of Rights is not an exhaustive list of rights. This is not every right that every American citizen has, and that we have to understand that other rights lay outside of this, and that you can't just assume, or the government just can't assume, that they can do whatever they want to outside of these concepts. And then finally with the Bill of Rights, we have the 10th Amendment. What this amendment states is the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So the 10th Amendment states is any power that is not expressly guaranteed to the federal government is held by the states and by the people. This is known as the Reserved Powers Clause, and this is very, very important. This is known as the Reserved Powers Clause. That means all states get every power not guaranteed to the federal government. This 10th Amendment is something that we saw in the Articles of Confederation. And this is where we have this constant fight within the United States as far as federal power and state power, and trying to balance where that power exists. And we see this conflict throughout all of American history. We even see it up till today. This is a huge concept when we look at the fighting of the Civil War.